Welcome to Harvard Voices on Climate Change. I'm Jim Stock, Vice Provost for Climate and Sustainability at Harvard. I'm an economist and director of the Salada Institute for Climate and Sustainability. This series takes the broader Harvard community on a virtual tour of the research done at Harvard on climate and sustainability. Each hour focuses on a different topic featuring one or two Harvard scholars. Today, we're visiting Harvard Law School to get some insights into the legal aspects of the massive changes to environmental law and regulation being implemented by the Trump administration. On March 12th, Lee Zeldin, the administrator of the U.S. Environmental Protection Agency, announced 31 actions on environmental deregulation. These include a reconsideration of regulations on power plants, reconsideration of the greenhouse gas rules on auto tailpipe emissions, and reconsideration of the 2009 endangerment finding that underlies EPA's climate rulemaking under the Clean Air Act. These actions come on top of other actions taken by the EPA, DOGE, and the Department of Transportation to freeze climate funding under the Inflation Reduction Act. The sheer magnitude of these actions make them tough to comprehend, and the fact that they have many overlapping legal authorities and interconnected case law, including case law not normally in the environmental sphere, makes it very difficult for a layperson to understand which of these actions are likely to be the most consequential, what are the legal foundations, and where things are headed. Fortunately, to help us understand this complex environment and its consequences, we have two experts from Harvard Law School and its Environmental and Energy Law program. The EELP is arguably the preeminent academic energy, environmental, and energy law center in the country. It focuses on legal analysis to improve environmental and climate outcomes and to support affordable and clean energy. I'll take a moment to plug its podcast, Clean Law, which I strongly recommend for those of you interested in the legal weeds of current environmental and energy issues. Today, we're joined by one of the co-founders of that program, Richard Lazarus, and by the executive director of the program, Carrie Jenks. The other co-founder, Jody Freeman, appeared on an earlier edition of Harvard Voices in November. Richard is the Charles Stebbin Fairchild Professor of Law, where he teaches environmental law, natural resource law, Supreme Court advocacy, and torts. His most recent book, The Rule of Five, is an engaging history of the landmark 2007 lawsuit, Massachusetts versus EPA, which I suspect will figure prominently in our discussions today. Carrie Jenks, I should also mention he's argued, I think, 14 cases in front of the Supreme Court. Carrie Jenks is the executive director of the Environmental and Energy Law program. Before that, she was a practicing attorney in energy and environmental law. She has deep knowledge of the area, and I should also say that she's a great teacher. Her guest appearances in my undergraduate climate policy class are a highlight for me and for the students. So let me just remind you, I have pre-submitted questions in front of me when we turn to the Q&A, but please submit any questions you have using the Q&A feature during the presentation and subsequently. So with that, let me turn this over to Richard and Carrie.
Right, thanks, Jim. So it's the 71st day of Trump 2.0, the second Trump administration. We only have 1,390 days to go. So John McCain famously said when he was a senator that he favored the scalpel of reform. The first Trump administration, however, he described as favoring the meat cleaver and not the scalpel. Well, I would say that Trump 2.0 in the first 71 days have been more akin to a nuclear explosion, with a bullseye on programs related to climate change. Carrie and I are going to highlight some of the things that have happened so far, are likely soon to happen, but just some of them. And we look forward to you asking questions on others as well. Typically, in these kinds of sort of reflections on the first days of administration, you just focus on the greenhouse gas regulations. Because what every administration has done in the past sort of 20 years is just whipsawing on climate regulations. Bush to Obama. Obama undoes everything Bush does and adds a whole new sweep of climate regulations. Obama to Trump. Trump comes in the first day, proudly announces his executive orders. I'm going to get rid of everything that Obama did and give up a whole new group. Biden then does the same thing first day. Executive order, I'm going to reconsider everything Trump did with a whole new sweep of rules. And now Biden back to Trump, and he's done exactly the same thing. On the first day of his presidency, day one orders issuing, we're going to consider and reverse everything that happened to climate under Biden. But today, the challenge of Trump 2.0 is far more than just those regulations. And we're going to talk about that. So we're going to divide our talk in two parts. Carrie is going to focus on the rules and regulations, some of the ones being targeted, but not all of them, but we're happy to talk about all of them. And I'm going to, like the movie title, I'm going to focus on everything, everywhere, all at once. Carrie?
Great. Thank you, Richard and Jim. So as both of you mentioned, we're a little over 2 months in, and it feels like a lot has happened, which is true, but there's still a lot to happen. So I'm going to try to organize my thoughts into 3 buckets. First, what has EPA done so far? What are we waiting for? And what are some of the options that EPA may be considering? And then what are some of the signposts going forward? So what to look for in terms of how the rollbacks might happen. As Jim mentioned, President Trump came in the first day with a series of executive orders, and then on March 12th, EPA released a series of press releases and fact sheets. So I'm going to start with the endangerment finding. And as expected, EPA confirmed that it intends to reconsider the 2009 endangerment finding, which is the determination that underpins EPA's Clean Air Act greenhouse gas regulations for the power sector, oil and gas sector, transportation, landfills. And the Clean Air Act doesn't just regulate air pollutants that go into all pollutants that go into the atmosphere. Rather, it only regulates the pollutants that endanger public health and welfare. So the endangerment finding is the trigger for the statutes. And I'm sure we'll get into this in the Q&A, so I'll just make a few points on how they might try to do this. So they might try to go after the science, though that would probably be the most legally risky, even for conservative courts. An alternative they might try is to argue that there are reasons other than the science, or in addition to some other questions they might raise about the science, for the agency to conclude that it doesn't have the authority under the Clean Air Act to regulate greenhouse gases, or at least that it has the discretion not to regulate. This would be an attempt to overturn the Supreme Court case, Massachusetts versus EPA. And it's aggressive for them to try to do this, but given the other legal strategies that we're seeing unrelated to environmental issues, it seems like it might be in line of how they do that. If they're successful, then EPA doesn't have the legal hook to regulate greenhouse gases under the Clean Air Act, so it is very significant. It's also important to note, though, that this is not what the Trump administration tried to do the last time. So this is different. Last time, at the very end of the administration, they tried to assert that some sectors didn't contribute significantly, like oil and gas, and therefore they didn't endanger public health and welfare. But this theory was never tested in the court. I think I'm worried and suspect that approach is not sweeping enough for this current administration. I think they're going for more legally risky strategies that have more damaging outcomes if they're successful. To give you a sense of what I mean in terms of their intent and how they're going to sort of go big, I'll read you a quote from the endangerment finding press release to give you a sense of the tone. So this is a quote. "The overhaul of the endangerment finding, along with other massive rules, represents the death of the Green New scam and drives a dagger straight into the heart of climate change religion. While accomplishing EPA's core mission of protecting the environment, the agency is committed to filling President Trump's promise to unleash American energy, lower costs for Americans, revitalize the American auto industry, restore the rule of law, and give power back to states to make their own decisions." There's a lot to unpack in that quote, but I'll make 2 points on it. First, EPA, based on the 2009 endangerment finding on science, is not a religion. Second, what's striking is that I don't think these industries, power, oil and gas, auto manufacturers, want this outcome. They may want changes to the rules, but they want the rules in place for legal as well as economic reasons, not to mention that many companies have commitments to mitigate climate change risk. Moreover, they need to remain competitive internationally, and their investment plans prior to now were part of their business strategy. Each action taken by EPA under Obama, Biden, and even in some cases, the first Trump administration recognized climate change, and the debate was about how to regulate, not whether to regulate. So now I think it's very different than what we've seen in the past. Shifting to some of the other rollbacks that were announced on March 12th that Jim mentioned, there were 31. So this included Biden's power plant greenhouse gas rules, the oil and natural gas methane rules, Biden's strengthening of mercury standards for coal-fired power plants, the car standards, particulate matter standards, air transport, interstate transport issues, regional haze, wastewater regulations for coal-fired power plants, and a host of others. So I think the list in and of itself was expected, but it's striking in terms of some of the justifications outlined in the press releases. The justifications focus on the economy and American energy, and there are other agencies in the federal government responsible for those objectives. Rather, Congress was created EPA to protect public health, the environment, and those objectives are barely mentioned in some of the press releases. That being said, each action that EPA intends to take is going to require the agency to prepare a proposal, take public comment, finalize the rule, and I'm sure those actions will be then litigated. And any regulatory action should need to be grounded in the statutory criteria that Congress has required EPA to consider, which generally has at least one component connected to emissions or pollution reduction. So if the rules increase emissions or ignore statutory obligations and only focus on cost to industry, it's going to be hard for the Trump administration to justify that. I think states and NGOs will have strong arguments to oppose EPA rule, even if, especially if the agency is arguing that it can't regulate these sectors because they need to unleash American energy. So at the moment, we're waiting for proposals to be published or released. And I can walk through two on what some of the options are that we expect. I'll focus on the greenhouse gas standards for power plants as well as the car standards. So the Biden EPA proposed standards that were based on a carbon capture rate for coal plants that intended to operate beyond 2040. And then it required us co-firing with natural gas if the plants wanted to operate between the 2030s and 2040s. So one question for the rollbacks is, does EPA now argue a standard closer to what we saw in the first Trump administration, which was efficiency standards, which many projected actually would increase emissions? Or do they follow the reasoning closer to Biden administration with co-firing or capture standard that has a much longer time frame and less stringency? Or what might be more likely is that they argue the EPA lacks the authority to set a standard and allows states to determine what's needed, and conclude that any standard that constrains American energy, which they're defining to exclude renewables and storage, is in conflict with the statute and court decisions, and therefore conclude no standard is necessary. For cars, I think there's a clear target both politically and from the Trump EPA that they want to roll back the EV tax credits, which were part of the Inflation Reduction Act that Richard will talk about. But they also want to roll back the EPA standards. Again, it will be important to see, does the administration take approach that's similar to the first Trump administration, which proposed very weak standards, or do they try to remove the standards in effect for tailpipe standards? But remember, if they win on the endangerment finding, then these rollbacks become somewhat moot. So in terms of timing, given what we're seeing from EPA and other agencies, I expect EPA to move quickly. And Richard can talk about how hard that's going to be if they don't have the staff to do that and the expertise that they need. But fast by any agency creates legal risk, and it's going to be important to see if those risks create problems for the administration. So what we're looking for, what are some of the signposts? It'll be important to see how do stakeholders comment on these rules? So what does states say? What does industry say? What do the NGOs say? And then how does the administration respond to that in the final rule? Last time there were missteps in the process. And so do the courts see missteps and do they kick it back to the agency to redo it? And then finally, what data exists to demonstrate the emissions and the public health implications of these actions? I'm concerned that EPA doesn't keep the expertise in-house and doesn't keep the programs in place to really provide communities with emissions data. And if that ends up being true, it'll be important to consider what voluntary actions stakeholders can fill the void so that we have robust and transparent data. That objective is important for communities, but I would argue also for industry. One final aspect that I'm watching for is whether the uncertainty and the chaos, which may actually be the objective of this administration, causes too much uncertainty for companies to keep making progress for decarbonization and public health. In the end, I think regulations, and we can talk about this in the Q&A, serve an important function, and that companies that are regulated need to know the rules to make the long-term investment decisions, and they need confidence in those rules to make those decisions. If we keep swinging back and forth, as Richard was mentioning, that uncertainty, which is exacerbated by the actions of the Trump administration, risk undermining the ability for companies to move forward. That being said, I think in the absence of EPA fulfilling the role of protecting public health and addressing climate change, that role will fall to the states, for those states that are willing to do so. And perhaps we can talk more about this in the Q&A, but I think we're also seeing, and I expect to see more of this, the administration is looking for ways to constrain states' authority. So that's also concerning. But Richard, I'll turn it over to you.
All right, thanks, Carrie. All right, what I'm going to talk about are some things where show, like Carrie has already suggested, how much more aggressive the second Trump administration is than the first when it comes to climate. I mean, Carrie said, dagger in the heart. You don't normally think of dagger in the heart as something to celebrate, but with this group, it appears to be. So I'm going to talk about three things. The first is the use of the Congressional Review Act. Now, the Congressional Review Act is a statute Congress passed years ago, hadn't been used that much, which allows the Senate and the House to pass a resolution by a majority vote, no filibuster, which basically overturns a rule put out by any agency, including EPA, within a certain time period of the Congress acting. And if they do that, if they kill a rule, then the agency cannot promulgate a rule that is substantially the same at all. They're completely forbidden from doing it in a future administration without new congressional legislation. So they've already done that once. And their target was a very significant rule put out by EPA during the Biden administration, and that is the methane fee. In the Inflation Reduction Act, Congress instructed EPA to impose a tax on entities emitting more than 25,000 metric tons of carbon dioxide equivalent per year. That's a really big deal. It's our first sort of carbon tax of any kind, and one that people will really celebrate is internalizing the cost and giving people a huge incentive without regulation, a tax. EPA promulgated a rule to implement that statutory provision. In March, Congress successfully targeted that with a Congressional Review Act. So they killed the rule. So we still have the statute, which requires the tax, but there's no administrative rule implementing it. And arguably, EPA is powerless to do a new rule. It's this odd situation where the statute requires the tax, but EPA has no power to do a rule in theory and implement it. And certainly this administration is not going to do it. So industry is kind of in a quandary. They have this tax, but they have no idea how to pay it, how to calculate it, and what to do. Now, next on the Congressional Review Act chopping block is also significant, but it hasn't yet passed Congress, but it probably will. And that is under the Clean Air Act, EPA has the authority to give California a waiver, which allows them to promulgate greenhouse gas emission restrictions even tougher than the federal government. And then other states, if California does this, can then adopt it. And California has done that in the past. And this has been one of these whipsawing things where Bush didn't do it. Obama did. Trump undid it. Biden redid it. And now we're in Trump 2.0. And they're not only suggesting they're going to undo it, they're actually suggesting they're going to try to kill it. And that is through a Congressional Review Act provision. And if they kill the California waiver, then arguably a future Democratic administration can't redo it because it could be substantially the same. That'll be the question without new legislation. And legislation is very hard to pass. We've had no new Clean Air Act legislation since 1990. That's 35 years. So there's some issues whether they can do that or not, legal issues that I can get into if people want to know, but that's a big deal. All right, next one. The biggest accomplishment in the Biden administration, I think everyone knows, is the Inflation Reduction Act, where because it wasn't subject to the filibuster, they could use budgetary processes, expenditure of money to try to achieve enormous reduction in greenhouse gas emissions in the United States. And actually, the Inflation Reduction Act is forecasted to cause dramatic reductions, 25, 30% or more reductions greenhouse gas without regulation, just through subsidies and the rest. For solar, for wind, for the construction of transmission lines necessary for renewable resources, for electrical vehicle charging. But the Trump has targeted that, the Trump administration. And you've seen this in the paper, probably not thought of it in terms of the Inflation Reduction Act. And that is they're trying to freeze billions of dollars of funding authorized by Congress for all kinds of things, USAID, other things, but also for all those things related to climate change. And they're trying to claw the money back so it can't be spent. So here's the legal issue. There's an easy part and a hard part. The easy part is it's illegal. The easy part is the president has no inherent constitutional authority to impound or refuse to spend funds already appropriated by Congress for particular purposes, full stop. The president can't do so because he doesn't like those purposes, that he thinks Congress was wrong as a matter of policy. He cannot do it. That's settled law. It's been settled since about 1838. And no president has tried to do this since Richard Nixon, who failed in the 1970s. That's why you may remember Trump put out this OMB memo within a week or so saying we're freezing all funds. They quickly retreated from it because it's blatantly unlawful. And they quickly abandoned it in litigation. It's also easy, once a contract has been signed and somebody has the money under contract, it's very hard to take it back because then the government is bound by contract. Now, here's the hard part. I wish we just had the easy part. The hard part is the Trump administration does not mind doing illegal things. They don't mind forcing the courts to act. And litigation takes time. And the practical effects of freeze and a contract, the sort of violation, the practical effect is it takes time to undo it. And in the meantime, money isn't being spent. The contractors aren't getting it. People's salaries aren't being happening. People are having leases aren't being paid for. The courts don't act instantaneously. And so right now it's chaos among all those recipients around the country. And you know the Trump administration will keep changing the legal rationale, making it very elusive on what their basis is. And they can make it narrow and narrow over time. And only to say we're pausing it while we study it more carefully. So the practical effect is quite serious. The worst case right now is the EPA's Greenhouse Gas Reduction Fund. That's $27 billion. That's a lot of money. That's basically 3 times EPA's own annual budget. Inflation Reduction Act was quite ambitious in that respect. EPA awarded those grants, $20 billion, they gave to 8 groups. At the moment, the Trump administration is claiming a lot of that was done by criminal behavior by the Biden officials. They're threatening them with criminal prosecution, the Biden officials with it. A judge has put a TRO, temporary restraining order, on the Trump administration, but has not freed up the money. So that $20 billion is still basically frozen, and those recipients right now, they're in disarray. And the question is how long they can last while the judicial process does its thing. The last issue I want to talk about is elimination of career staff. In December of 2024, so after the election and before the inauguration, Carrie and I, among a couple other people, were invited down to EPA to visit with the Biden administration the political appointees at agencies like EPA. And they told us then what their greatest worry was. They said, we know the administration will come in, and we know they're going to try to reverse all of our rules. We think we've done a pretty good job. They'll succeed on some, they'll lose on others. I think the motor vehicle rules are pretty strong. The power plant rules might be more vulnerable, but they'll win and lose some. But when we come back in 4 years, they said optimistically, we'll get back to work, unless they destroy the career staff. If they successfully get rid of the career lawyers, scientists, and economists at EPA, if they successfully destroy that deep level of expertise, When we come back in 4 years, we can't get our work done. Because the career people make policy decisions. It's those career experts. They do the work. That's why when Obama comes in 2009, they could have put out the proposed endangerment finding by May. And that's because they had all that expertise there. The Bush administration had done nothing to kill it. They let scientific research happen, economic analysis happen. So that was good. But this group is trying to kill it. They're doing it by firing people, suspending people, dismissing them, transferring them from jobs to work instead on sanctuary city issues with immigration. They're threatening to eliminate offices like the Office of Scientific Research in EPA, get rid of all the employees, about 1,500. And they're doing this regardless of illegality. Most of the stuff they can't do. These people have some protections. But again, they're going to threaten to do it. In some agencies, like today in HHS, they're doing it. And it takes time for that litigation to happen. It takes time to resolve those issues. And people need their jobs, they need their paychecks, they need their health insurance. And the fact is, it causes enormous disruption. And that's the goal. The stated goal of Russell Voigt, now head of EPA, is to cause trauma in these career people so they don't want to go to work in the day, any day. Many are leaving. They don't want to work to a place where they're being diminished. They're demoralized. Their spirits are crushed. And they have no desire even to stay necessarily for the long term, knowing that people are looking for an excuse to fire them at any moment. There has been a lot of departures from firing, which will take a long time to work out. There's a lot of voluntary departures of really good people who plan to have their career with the federal government. People who do public service and whose work we depend upon. That's going to be, and Carrie hinted it, that may well be the biggest problem we have going forward. Climate change is an issue where time is not fungible. When I sometimes teach climate change in my classes, I will show a clock that's going tick, tick, tick. Because all people who care about this issue knows the longer it takes to bring greenhouse gas emissions down in the atmosphere, the exponentially harder it is to avoid some of the most catastrophic effects, some of which can be irreversible. And to lose not just the regulations, but potentially lose that career expertise and the funding of the IRA is potentially devastating. And it's being done even though most of it's unlawful. Thanks, Jim. We're ready for our Q&A.
Hey, thanks so much, Richard and Carrie. There are a bunch of questions, and let me just remind you to drop more into the chat. And I'm going to start. It's so hard to know where to start even. So I'm going to start off, Carrie, going back. I'm going to ask some fairly specific things. So, Carrie, you alluded to, but Richard, you can weigh in on this too. You alluded to, or you discussed in some length the endangerment findings and the strategy there. But I was wondering if you could just explain. I think there was a lot lying under the surface of what you were saying, and I wonder if you could explain a little bit about this legal strategy you suggested, which is simply asserting, if I understand it right, simply asserting that greenhouse gases aren't eligible for CAA coverage. And so my understanding is that that assertion would automatically be rejected by, for example, the DC Court of Appeals because of existing law, which is the existing decision, which is Mass versus EPA. So then it would be kicked up to the Supreme Court. And then the hope would be that the Supreme Court would overrule Mass versus EPA. Do I have that right? And if so, maybe you could provide a little gloss. And Richard, you've written a book on Mass versus EPA, so you could weigh in on this too. Or
yeah, I'll just say,
Am I
Yeah, no,
missing?
I think that's exactly right. And I'll let Richard, because he
And
is
then,
the
and then
expert on this.
and the other part of background is the endangerment sign finding says that greenhouse gases are are harmful, and the science on that is so overwhelming that that's not going to that would be very difficult to actually say yes. In theory, carbon dioxide and greenhouse gases could be regulated, but no, because they're not a potential harm, and the science there simply wouldn't support that.
Yeah,
Yeah, I think,
go ahead, Carrie.
no, I think you're right, Jim. I think the science is, I agree with the science. I think they might try to inject some uncertainty as they talk about it. I don't think they rely on it to decide the case. I think they would, though, be looking at the dissent in Massachusetts versus EPA, which disagreed with the decision. And it was more saying there may be science that shows that it endangers public health and welfare, but EPA has authority to decide that there may be other reasons not to regulate. And that was in Scalia's dissent. And I think, as Richard, I'm sure we'll talk about, the court has shifted and may be willing to overturn its past decisions in a way that makes sense for them to tee it up and see what happens. But
Yeah,
Richard,
I quibble a little bit at the edges. I think you're right with the DC Circuit. The precedent's very strong. The DC Circuit actually upheld the endangerment finding. They upheld it. They rejected a lot of the legal arguments that the Trump folks are now suggesting. It was unanimous. It included Judge Sentel as a very conservative judge. Now, so they're really seeking Supreme Court review. The Supreme Court, though, has never addressed the issue. They've never addressed the issue whether greenhouse gases endanger public health and welfare. What they ruled in Mass versus EPA is that they are pollutants.
Yes.
And that EPA had not given sufficient reasons for deciding not to determine whether they endanger public health and welfare. But they did not say that they did or didn't, or they did not say the EPA had to decide they endanger. They said the reasons you gave for not deciding the issue were unlawful. But they didn't say greenhouse gas endanger. And they left open the possibility the EPA could have other reasons for deciding not to decide. They just hadn't given any legitimate reasons. So you don't have to overrule Mass versus EPA at all here. So what they're going to try to do, and this is absolutely right, and everyone is suggesting, if the administration tries to do it, saying that the science doesn't support it, they lose.
Yeah.
That is a laughable proposition. So they will try to find some legal argument for saying that they've misconstrued the word endangerment as a matter of law. They misconstrued what factors are relevant as a matter of law. They can't touch the science because that's silly. So we have a sense of what they're going to do because it's in their press release. One is they're going to say that it doesn't endanger because EPA, considering whether a pollutant endangers, has to consider the cost of regulation as well as the harm caused by the emissions. All right, so that's one legal argument. They will lose that legal argument. They lost the DC Circuit, they'll lose it in the Supreme Court. There's no text to support that argument. So that's an argument which won't work. They then are going to say another thing. They're going to say, well, the word endangerment means when EPA did it, they considered all greenhouse gas emissions, whether they endanger. They didn't consider just the ones emitted by automobiles. And they should have done just the ones emitted by automobiles. And so they based their calculation on too broad an inquiry. They had to do it because the first endangerment finding was for motor vehicles. And they considered some greenhouse gases not emitted by automobiles. Now, everyone knows you can eliminate those others and we'd still be there, but they don't care. They're just going to try to say, as a matter of law, they made a legal mistake. Now, we're going to have to go back and look really carefully at EPA's endangerment finding and all the science they have there to see whether, in fact, they're right about that, or whether they're right on how EPA decided it. And we have to consider, what all the reasoning and whether that works. But that's the kind of thing they're going to try. They're not going to They don't have to ask for mass versus EPA to be overruled. Now, if they're in front of the Supreme Court, they might well throw in the argument. Looking at this court, they'll say, hey, this is not the court to decide a mass versus EPA. And in fact, all 5 justices of the majority, they're gone. And all we see are justices who were in the dissent. So they might raise a different issue they haven't forecast yet. And that is to say, greenhouse gases are not pollutants.
Yes, right.
Now, the DC Circuit can't revisit that. The Supreme Court could revisit that. That's not whether they endanger, it's just whether they're pollutants or not. So that would be asking them to overrule mass versus EPA. Again, not on endangerment, but on pollutants, and that would kill them from the Clean Air Act. Now, I think there's no question that if this Supreme Court had that issue ab initio in the first instance, there wasn't the old case, they would rule differently. They would say greenhouse gas emissions aren't pollutants. This is a very different court. Why, though, it's not clear they'll do that if the new administration raises that before the court, is that the Supreme Court almost never, when it overrules itself on a question of statutory construction, the meaning of a statute. You look at Supreme Court cases that overrule other Supreme Court cases, they're questions of constitutional law. The court's rationale is, if we decide something a matter of constitutional law, only we can change it. When we decide something a matter of statutory construction, if we're wrong, that's Congress's job to change it. So you can look at lots of places, you're just not going to find that precedent of statutory construction. They could still do it here. They certainly have the power to do it. It would be highly abnormal for them to do it. But as we know, these are not normal times. But that's how mass versus the EPA comes in the pollutant question, not on the endangerment question.
That's fascinating. Is it relevant that in the IRA, there was this line included that says that CO2 is a pollutant?
Well, I mean, people like to say it is, so they'll make that argument. I don't think it is, because it says, for the purpose of this section in the IRA, it doesn't actually amend the Clean Air Act and the definition of pollutant in the Clean Air Act. It only says, now, but that's not a bad argument. You can say, I'll tell you the good argument. I'll make that argument. You say the congressional ratification. Here's the other thing, Jim, which means they might not do it. There have been 2 cases since mass versus EPA where they have relied on it. They relied on it in their own rulings. A case called American Electric Power v. Connecticut, where they held the federal common law was displaced, relying on mass versus EPA. And the Utility Air Regulatory Group involving the Prevention of Significant Deterioration Program, they relied on mass versus EPA. That makes it even harder for them to overrule it because they themselves have since relied on it.
Oh, so this is, I'm sorry. I know there's so many audience questions. I can't help but ask this next question. So if that's the case, then would they go back to American Electric Power versus EPA saying that that would have been wrongly decided? So therefore, California can set its own GHG emissions because it's not regulated as a pollutant by the federal government, which means that California could use that argument to set a new ZEV standard when they have the California ZEV standard under the Clean Air Act withdrawn by the administration.
Right. And that's the argument that immediately people will make, that the federal common law is back.
Yes.
Because it hasn't been ousted.
Yes.
And there'll be a healthy debate, but I can tell you it's not clear. Because if you read American Electric Power v. Connecticut, the question is not just whether EPA regulates it, but it's whether Congress has addressed it. And what the other side will say is Congress deliberately decided not to regulate it. And Ginsburg's opinion doesn't say that the question is whether or not they regulated it enough for federal common law purposes or adequate, but whether Congress itself, by passing the Comprehensive Clean Air Act, has decided to displace the federal common law. So that'll be the debate. People will say, aha, let me put it this way. We're much better off if they don't overrule it than if they overrule it.
Okay, so I'm going to stop being an economist pretending to be a lawyer, and I'm going to go to some of the questions here, because we have a whole bunch of really good ones. I'm going to So since I raised the California waiver, and since Carrie, I think it was you who discussed the California waiver, are there other a question from the audience is, are there other mechanisms in which the California ZEV standard, which is no internal combustion engines by 2035, are there other mechanisms, other legal mechanisms whereby they could achieve that same objective, even if the California waiver were withdrawn?
Yeah, there's ongoing litigation that's ongoing about the California waiver. And so it will be important to see where the Trump administration decides to play and what side they go forward on those cases. Richard, I don't know if you want to speak more to the litigation itself.
Yeah, I mean, if they do the Congressional Review Act, that's hard. On the other hand, there is a serious issue. The Congressional Review Act doesn't apply.
Right.
It only applies to rules.
Yeah.
And if this is not a rule of general applicability, it's a license.
Right.
And the General Accounting Office is basically, that's their position. It doesn't apply.
Yeah.
What one does, though, if EPA submits it, they have, and Congress acts, then you've got Congress saying we think it is. So we're kind of counting on the parliamentarian to make a ruling that the CRA doesn't apply. They do that, that's very hard to overcome successfully. If they do the litigation attack that Carrie talked about, then we've got arguments on both sides.
Let's just carry this and this is just for sort of a general thing, just to carry this out. Suppose that there's no authority that's related to the Clean Air Act that becomes available to California. Can they simply just pass a new law and says, hey, we're California, we've decided that you can't sell this particular product here after 2035? Or is that like going to be a violation of the Commerce Clause or something? And can you just explain that?
Carrie, you want to go ahead?
No, go ahead.
Okay. No, that's a great question. Because it's one thing to say American Electric Power and federal common law comes back, which may or may not. It's another thing to say, well, if EPA is not regulating car emissions, then why are states preempted from doing it? And on that one, that's a stronger argument. They don't need a waiver because there are no federal emission standards which they're interfering with. And in that one, it's not at all clear there'd be any preemption. That's a better argument to make because the Clean Air Act has an express non-preemption provision for state law. California was regulating motor vehicles before the Clean Air Act passed. The reason why industry wanted the Clean Air Act in 1970 was to include that preemption provision based upon the federal emission standards, which they had limited for California waiver. That's a good argument. We'll just have to see how it plays out, but that is stronger on its face than the resurrection of the federal common law.
Okay, that's really helpful. So we had a number of questions submitted that were around NEPA and permitting. What's any predictions about NEPA's persistence into the next decade? And then I think there is one here. Oh, I'm sorry. I'll look that up. But there's a number of questions about NEPA and permitting and how that all intertwines with this. And I don't recall you're discussing this, or you might have been passing, Richard, but maybe you could say some words about first of all, NEPA, which is actually in itself a pretty controversial statute, simply because even on the folks who have been, who are really strong solar and wind and transmission advocates, there's been a lot of frustration with how long it takes to get permitting done. So this is sort of very much a top of mind issue on both sides of the aisle. I wonder if you could say a few things about NEPA.
Yeah, you want me to go ahead, or do you want to?
Go ahead, and I'll add to that.
National Environmental Policy Act.
Yeah, go ahead, and I'll add to you.
Okay, so NEPA, National Environmental Policy Act, it's one of our longest laws, often referred to as the Magna Carta. January 1st, 1970. It requires federal agencies, before they do any major federal action significantly affecting the quality of human environment, do an environmental impact statement. It's sort of a look before you leap. As you said, Jim, it's caused a lot of some kind of rethinking. It's been a great law, but with the need of climate and the demand to get things permitted and constructed and done quick, because that climate change clock is ticking. Some people, there's a real potential for bipartisan reform in Congress on this issue to allow more fast tracking, including NEPA analysis. So this is actually an area of real potential constructive bipartisan litigation. That has not so far been the approach of the Trump administration, because I think that would get passed.
Yeah.
It would get passed with, and some people would be unhappy, but the national environmental groups, I think, would be in favor of it. A lot of the states, everyone could say, we got to get this done. What the Trump administration done is, once again, more radical than anything else. CEQ has authority for decades to promulgate regulations which implement NEPA, exactly what one needs to do, the impact statements, how they have to be, and all the rest. Now, NEPA's authority is not expressed in CEQ's authority, the Council on Environmental Quality, and the Executive Office of the President. Their authority is not written in the statute. The source of it has been, at least historically, an executive order put out by Jimmy Carter in 1977, which said, CEQ, you have that authority. And CEQ did it, and it meant that all the agencies had to follow CEQ, and all the agencies didn't have the authority to write their own regulations regardless of CEQ. So it was sort of efficient to have one authority speaking for it. Well, guess what? In one of the very first executive orders put up by the Trump administration, they revoked Jimmy Carter's 1977 executive order giving CEQ that power. If that holds, that means CEQ can't put out the regs. And the statute itself is pretty bare bones. You need the regs to know exactly what to do. And as Carrie suggested, industry and everyone wants to know what to do. They don't want uncertainty. And it means that instead you have to wait for all the agencies to do their own CEQ, their own NEPA regs. So it's a little chaos and uncertainty, which actually doesn't help things. People bring lots of lawsuits. And what we need here is, and it's there for the taking, it won't be uncontroversial, but it would pass, bipartisan reform for permitting of facilities needed to address the climate issue.
I would also add, one of the best ways to get permits to move fast is to have staff in place that are reviewing the permits, like butts in the seats. And so to the extent the Trump administration is getting rid of, making it more complicated for each agency to do it and firing people, it will delay the permitting even more so.
There are quite a few questions on the discussion about internal capacity. Try to keep this quick. Jim Engel has a really good question. Our colleague Jim Engel from the English department asks about, is there any chance of there being a temporary restraining order on the cuts to EPA staff, which I think is probably a more general question about these cuts. So why don't you just do a quick on that, and then I'll go to some of the other capacity questions.
Yeah, I think there is. I mean, they haven't really done it a lot with EPA. A lot of the EPA has been targeted more in press releases, statements by the President of the United States saying we're going to reduce it by 65%, a bunch of the environmental justice, but they haven't really done wholesale dismissals yet at EPA like they've done at some of the other agencies. It's more sort of in terrorem threats of what they're about to do, which is causing people to leave without it. When they actually do it, like the Office of Scientific Research and the rest, there'll be suits, there'll be TROs that are brought, like some of the others. They're saying all the USAID people can come back, but they really can't come back necessarily as a practical matter. So yes, we can get a TRO, I think, if they actually make the move. But the question is the practical effect of it actually, if they can still then do the work, if they're allowed to do the work, or they're just so dispirited that they move on. Hi, Jim. I like Jim Engel, by the way. He's one of my favorites.
There is a question, if there is this loss of capacity, and there's a number of different ways to think about it. Loss of capacity in the Justice Department to actually go back and actually handle all the lawsuits that are stemming from this, and then loss of capacity at the agencies if you are going to repropose. So suppose that they decide to repropose a power plant rule and a tailpipe rule. That's a ton of work.
Right.
Somebody's got to do this work. So there's references to like 3D chess here and that we don't actually understand what's going on. What's going on?
Carrie, go ahead.
That's not a coherent question. Is that a coherent
Well, no,
question?
it is. It's one that makes us smile a little bit. Carrie.
Yeah, I don't think that's the goal is to create chaos. I don't think the goal is to, I think they don't care. I think Richard said they don't care if they lose on some things. I think the goal is just press releases and fact statements. I mean, they framed the March 12th as the biggest deregulatory day in history. There was no deregulatory action. There was a press release that they intended to do something. But I do think without the staff to do it, it's going to be hard. And I expect them to make mistakes.
And they're going to lose cases.
But that's not Project 2025 was quite well thought out, and it's clear that there are people who have deep understanding of these connections. Like we were emailing before about what's the name? The review board, the Internal Merit System Review Board.
Merit systems and the employee work. Yeah.
Yeah, and so taking off one of the people on the board so that they no longer are able to meet and decide is in some sense very understanding. Maybe you could elaborate on that, but deeply understanding some of the workings of the U.S. civil service system.
Yeah, no. If you get rid of the Merit System Protection Board, the quorum and things needed there, then it's very hard for the employees who've been fired to get relief. Everything takes longer. You're absolutely right, Jim. We were asked the question. This means the Trump administration will not have the resources necessary to write new rules on any of this stuff. And when they do, they're going to make mistakes. And they won't have the lawyers at the Justice Department with the deep expertise necessary to do the best possible thing in the court as well. So they're likely not be able to do a very good job on the merits, not do a very good job when they're trying to defend it in court. So they're basically, doing these contradictory things. And there are two conclusions one can make. One is they're completely and utterly incompetent and they don't know what they're doing. The other is they're crazy like a fox. And that is, as Carrie said, they don't really care. What they really want to do, they may try to get stuff done. They want to make it so the next administration is powerless as a practical matter. So they care most about the chaos. But industry is not going to like that chaos. And the question is, when does industry come in and reject? Let me give you an example. Historically, the reason why Ann Gorsuch was basically dismissed or had to resign under the Reagan administration was industry went to the White House and said, we can't deal with this uncertainty. This uncertainty is killing us. We need a certain rule so we know how to make investments. And the issue here is, when is industry going to show up? And does the administration care and say, this isn't tenable for us?
I would say in the past 5-10 years, industry moved from not wanting regulations on greenhouse gases to the debate being just how to regulate and the time and what's the trajectory and the timeline and the steep of the reductions. Everyone, I think, got to a point that they are making reductions. It's just about how and how quickly. And so the fact that there would be no greenhouse gas regulations is really unsettling for industry. It's not what I think the majority of different sectors want.
They think they can make money on electric vehicles, the car companies. Just tell us we can make a killing. Don't keep changing it, right?
There's a question about whether there are any areas where we actually would expect some regulatory action, like clean drinking water, or lead pipes, or things that actually are sort of very tangible that go back to away from the climate side to more sort of direct whatever, health, toxic chemicals, that sort of thing. Do you see anything along those lines?
I think it's much more likely get rid of the word climate, which is somehow like, Darth Vader, the thing that shall not be named. If you get rid of climate, you talk about public health and toxics and drinking water supplies in local communities around the country. You talk about coal ash and coal ash residual and its impact on local communities. I think we're on stronger ground. I don't expect those areas to be eviscerated like climate. For some reason, right? They've got this thing about climate, and they call it a religion. I mean, it's sort of twisted. But I think a lot of the other stuff, I don't expect aggressive positive things, but I don't think it's all going to go away. And they're going to look for examples. The contamination of Palestine, of East Palestine in Ohio, right?
Right.
Yeah, they're there, and I expect they'll address those issues.
Yeah.
Yeah,
Yep.
PFAS would be another one where there's so much
Right.
concern from a public health PFAS
Oh, yeah. PFAS, yeah.
Yeah.
Well, I mean, that's an area where we'd actually align with Kennedy's agenda at HHS too. So those sorts of toxic chemicals.
Yeah.
Right.
Right. So that's helpful. So I'm going to ask a difficult question. We have now sort of two.
And that's for Carrie to answer.
But I'm going to ask, but we have a great question before that. We have a great question from a Harvard College student. As a student looking to pursue a career in climate policy, what do you recommend we look into? And where do you see the biggest spaces for impact?
We both, I'm sure, have similar but different answers. I think it's figuring out, when I think about policy, there's a lot of different pieces that go into that. So it's, information about technology advancements, information on cost. If it's energy, thinking about reliability, the energy system, emissions data, public health data, agencies need all of that information to create a durable rule. And so I think it's figuring out from a student's perspective, what do you enjoy most? And then how do you contribute that expertise into the policy conversation? But that expertise can come in a number of different ways. And agencies need experts in-house and externally to give them good information so that they can make sound rules.
Right. And that would explain right now the states. The states are going to be major players. And they're doing very inventive and creative things, quite important on the climate issue. And so is the private sector. The private sector, there's the private sector out there which thinks if they build the best, most efficient device which helps address the climate issue, they're going to make $1 gazillion. Yeah. I mean, coal's not going to come back, right? So if you can come up with those products, it's going to be very important. Here's the other thing I would say to someone in this interest in this area. This is a tough time, but don't despair. If you really care about the climate issue, this is your time. This is the time you can make a difference. This is a time when you can't just sit back and be passive. This is a time where, in fact, we need responses to these threats. We need the best minds, the best people to come together and focus on these issues.
I think that's really helpful, Richard. So let me follow up my final question, which is my question, but there's a number of they're similar in the chats and so forth. This follows up on your remarks, your digression or my comment on private sector. It's got to be the case that it is the case that one of the things that is at a very meta level providing some resonance with all of these actions is the dislike of the regulatory state. And there is no question but that the regulatory approach to climate or to other things increases costs. It adds red tape. It makes it more difficult for businesses. It interferes with people's daily lives. Whatever we think about climate and so forth, you can understand how people would prefer to have the option to purchase a regular, internal combustion engine vehicle and so forth. So between that, what I think is this palpable sense of public concern or public opposition or public frustration with the regulatory state in the environmental sphere, and then the Supreme Court being quite negative because of its recent changes, what sort of rethinking do you see at sort of a high level, you folks, you were founder, Richard, and you're the ED of the Environmental and Energy Law Program. Like, what does this mean for an environmental energy law program if you really step back? And you've got a minute to answer.
Well, I would push back a little bit that I don't think the rules were mandating, the federal rules were not mandating that you had to buy an electric vehicle versus an internal combustion engine.
California's were.
Federal.
And the federal were, I will push back on that because in effect, the federal rules really were too.
I think they were driving it, but I also think you design regulations so that you follow the market trends. So if you looked at what the auto manufacturers were proposing to do on their own and where EPAs were, they were there, and the rules, I think, make sure you get there. And then I think you design rules so that if something happens that is too costly, there's sort of an off-ramp at the end. And so that's, I think, what the role of federal regulations are. And so I think the question is, can you keep industry moving, even if it's not at the same pace, and states keep moving so that you continue some of that progress? But the chaos is making it hard to even know where to go. That's the problem.
The only thing I'll add, a little bit of 2 seconds we have, is no question there's been an enormous failure of communication in terms of climate change and the impacts and environmental law and regulation. I mean, I view it as one of the great success stories of the past 50 years. These laws have done dramatic improvements that would satisfy any cost-benefit analysis in terms of improving the quality of the water, improving the quality of the air. While we've had a very powerful, growing economy, at the same time, you look at other parts of the world, had that kind of growth without those kinds of laws, disaster happens. So I think it's been a big success story. And it's one which doesn't require a movie, which shows Al Gore telling people what the truth is from his Harvard days. It requires people understanding what it means to farmers, what it means to people who fish, what it means to real estate, what it means to people who live in erosion-prone and wildfire vulnerable areas, what it means to people and why it makes enormous economic sense to do this. And I think we've done a very bad job of framing it, and the other side, who I think irrationally have been very successful in a framing which basically makes people not trust any kind of regulation, and somehow climate's the worst of the worst.
Okay, Carrie and Richard, thanks so much for joining us. This has been a great conversation. Thank you for joining us in the audience. Thank you to the Harvard Alumni Association and the production staff for pulling this off. Thanks very much.
Thanks, Jim.
Thank you.